Just checking, make sure everything's good. Making sure everything is good everywhere. That looks good. All right. Good afternoon, everybody. As we bear in on day 3, a shortened day started like 45 minutes ago. We'll catch up. We're going to finish together with them. Don't worry. We're not going to miss anything. I'm giving you all the juicy parts. That's why we're here. So without further ado, let's jump on in and see what we got going on. I'm going to remind you that if you walk in late or anytime, you want to know what's going on, who's up there, who called them, etc., etc., you'll check a Chiron at the top of the screen, and it'll be there. Let's get this
session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grunander, Ryan McBride, Lauren Hunt, David Sturgill for the state, County Attorney Jeff Gray, and Chris Ballard are also present.
Good afternoon.
Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol to maintain security and decorum,
we're going to do this really fast.
Exits the courtroom during proceedings will not be
no one cares
to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include these extreme protections on electronic devices and
don't care about this.
or private discussions by recording equipment or by those present. And as you know, the microphones on your tables are turned off.
These are just rules for how the court operates.
Second, the court will address the camera and still photographer. Camera operator and still photographer.
He's going to address the photographer. Calling up the photographers now. He's the videographers.
Good afternoon. Please state your roles for today's hearing.
He's basically having them state their roles, that they're there to film everything, and they're not going to share stuff that he doesn't authorize to be published to the public.
Recording and entering of the proceedings.
And the rules of photographer.
And have you both reviewed court standing in order? You understand the requirements set forth in that order as they apply to your activities today? Yes. Do you require additional time to review the order or to adjust equipment to ensure compliance? Do you anticipate any difficulties complying with the order? No. Thank you both for your cooperation. As we begin this afternoon, court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any
No cell phones.
cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption.
Put your cell phones away.
The dignity and respect which they are entitled to. Consistent with the court standing in decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, and
Don't worry, when we get to actual testimony or any evidence or arguments, we will have this in a speed that you'll understand. I actually understand what he's saying, but I feel like most of you probably don't.
The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week.
We're finishing at 5 p.m. on Friday. That's it.
A substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause. And with that in mind, I ask counsel to remain mindful of the time that remains and manage your time.
Standard is probable cause, not beyond a reasonable doubt.
And with that, I wish to inquire a brief overview on what is anticipated from each party and where the court has a roadmap on how we are proceeding for the remainder of this
So
preliminary
he's
hearing.
asking now for a brief overview of what do we got going on now so that we can sort of, understand what we have left to do on this afternoon, Thursday, Friday.
First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Faumina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael Burt for Mr. Robinson. Judge, we have two remaining witnesses, Ms. Oliver from the ATF and Ms. Carner, also from the ATF.
All right, and to both
four more
parties,
witnesses.
thank you, I appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge.
Just want to highlight one issue for the court because it may be
that the court wants to do some time management.
This is Novak
State
for the
is gonna
defense.
proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concern about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Gernander, do you wish to be heard?
Yes, Judge. Your Honor, the state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right. Well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you.
All right.
All right. Does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence, except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles really at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding.
Gatekeeper is his judge role.
Rule 104A means the court can consider evidence even though its admissibility has not yet been determined.
Again, he's sitting there. There's no jury now. Okay, it's preliminary hearing. He alone decides whether or not there's probable cause. So what he's clarifying there is you have two roles. You're sitting there as a judge on deciding what evidence come in, and you're also coming in here as a determiner of the trier of fact to decide what facts you think are true and what facts you think are not true. And then ultimately you're going to take the facts that you decide are true or likely true and use that to establish whether or not there's probable cause to hold Tyler Robinson for a murder charge before a jury.
In his gatekeeper role. And then after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers.
So what he's saying is that if you're trying to decide is something admissible, you can rely on evidence that would not be admissible in order to determine the admissibility of that. Okay.
When acting in its fact-finding role.
That's here at this stage in preliminary hearing, obviously not at trial.
Only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge is a gatekeeper considers that a fact potentially inadmissible is not tainted. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that's conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So, in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record. I ask 3 steps: admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other may say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will
Send
urge
out
the
people who
parties
may
to,
testify.
monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there's a bit of distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
I just need some other tables besides 3, so we can try.
All right, if you all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind
Let's move
turning off your
faster.
monitor and then turning it back on, and if I could borrow somebody to do that to the witness monitor as well, so we all can see things. So I appreciate
While
that.
they
And
sort their
again, let me
technical
know, just give me
difficulties,
the
I'm going to
record.
speed
Talk
on
about
through
this one first.
until we get to a witness being called by the state.
Where would that TV go? If that doesn't address any security issues, let's do that. I just want to keep that TV can be more flat and it's not sort of viewed, and then we can look at that TV. Again, transparency needs to be viewable, not just there.
All this discussion
All right,
about fixing the technical issues, I was obviously something
I see.
that
Can
you
have
know
someone
I
with your
care
laptop plugged
about.
in so we can test it. We can check if it's receiving the data or information from your laptop to allow us to project. That may be the issue. All right, let's take a look here. I appreciate parties' patience, especially after I just said we're at that point. All right, so is this laying for defense, for prosecution? All right, and on the screen monitor here, looks like something came up. All right, and all right, we'll just hope the monitor for the witness works as well. All right, so ready to go? Just bring it in and go ahead. We'll get started. How much time do you need for that? Well, let's go ahead and proceed, and then when we take a break, we can do that. But for now, if you can see that TV, if you have any problems, please let me know. And we're going to bring that second TV. We just want to get the train on track here. All right, Ms. Hunt.
City Hall Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did,
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, I'll go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training experience within law enforcement. What roles have you had at SBI?
I began as a call enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, officer involved critical incident teams around the state of Utah and within SBI. I've been on dozens of those.
I'm a
things.
cop's cop.
And within major crimes of SBI, I've been we've worked a variety of cases. I've worked anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on the job training or did you receive specific training or
like such a
conferences,
cop.
things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement.
That's a lot of
I also currently
homicides.
work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a Faro certified. It's a 3D Faro scan of crime scenes.
What's a Faro scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on. I'm I've been certified as a forensic interview in the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the cases as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case if applicable to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have 2 case agents on a case?
It can be especially on a large case. Yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
Oh, if you notice, she like sort of does like a little check mark. This is indicative of an attorney who professionally is basically has a checklist of things she wants to cover. She wants to make sure she knocked off and got on the record. So when she gets the answer she wants, that's where you see her make like a little pause, make like a little mark. So
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Warren Police, Utah County Sheriff, Washington County Sheriff, St. George PD.
I heard that Twiggs is not going to testify. There was talk about whether or not his interview would be shared with the court, like uploaded, but he's not going to testify. We talked about this yesterday morning, I believe. And the reason you wouldn't want him to testify is because he's likely to just change his story somewhat. Because every time you tell a story over, it changes moderately. So if the state can get away with it, which seems as if the judge is going to let them get away with it, that they're not going to have to put the boyfriend Tyler's boyfriend Twiggs, Lance Twiggs, on the stand.
Most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about so as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elshulz requesting that I travel to St. George. Who
is Sergeant Elshulz? What agency is Sergeant Elshulz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes. So we traveled to the Salt Lake City Airport to a hangar there, and we were flown down on a fixed wing aircraft. It was Sergeant Elshulz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride, and myself, and the 2 pilots.
And who is Ryan McBride? With
the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office?
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device. And so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. Or I guess, how did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by FBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by FBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Yeah, I would think so.
Was he formally arrested at that time?
After all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me. Where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, can I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
You're just going to do the redacted version.
We're going to do the redacted version.
That may happen a couple more times as we go through exhibits
I
because of agreements and
We
disagreements
can't totally hear everything you're whispering when you're whispering. That's going to be the redacted version.
that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was
There we go.
seated and waiting.
There we go. The interview with Tyler Robinson.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, redaction of the video. And I would ask to publish it both to the courtroom and to the,
Give it to us.
Mr. Novak?
Silent, correct? Ms. Hunt?
yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so,
She looks confused by that. No audio? What's the point?
That's correct, yeah.
we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up conforms with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Oh, that's probably right.
So they realized that he's whispering too loud, so that's why they muted the mic. Oops.
It has no audio, so we would like to admit and publish it at this time.
All right, State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically.
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
Are we really not going to get any audio?
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And all the
Dressed in the same clothing he was wearing when he shot. That's the same clothing, the same red shirt, right?
so we are watching it on video. What
Same hat.
is he wearing at this time?
He's working a dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th. Is that right?
Yes, that's
In
correct.
2 days
Did he
he changed
remain
his
in
clothing?
Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail.
Why not?
Which gives the individuals personal identification of the
That's
charges,
ridiculous.
the probable cause statement, and then it's signed and
I'm
submitted.
sure the defense is going to want to try and fight to keep it out. So they want to basically say you can't use it now, and they're probably trying to keep out his admission on some basis.
To the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning. And then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Falmina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name is Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Durfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Durfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George courthouse there. They met and discussed briefly. So they kind of talked generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admission or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
Foundation basically means you're asking him a question. You haven't established any reason as to why he would know the answer to the question.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as States Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see him.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt? The same place.
All right, let's turn off the audio. That's good.
And
Yeah,
how do you
better.
know that?
I reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So
And Kimberly, if I can have you slowly scroll down.
So again, Mike Mitchell is the guy who ended up basically bringing Tyler in. He's a family friend who's like a former cop. Okay. We've gotten better at taking care of the volume. The
Sorry,
audio-
Judge, if I could just have a moment.
You may.
Yeah, that's what they said. That's what they say about her.
I apologize, Your Honor.
I haven't been impressed with her at
misspoke.
all.
It's not 14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only.
Easy girl.
Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it?
Thanks, Darren.
depict-
Make sure
is
you
it
guys
fair
hit like and
accurate,
subscribe.
From what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission.
Hey, bro.
States
Catch
Exhibit
you later.
14 into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, can I have a copy of it? What I
Why
have
not?
Is an unredacted version. So I want to review it before I make that decision.
If I may approach.
You may. Thank you.
While they're silent, I'm just going to remind you that this week only there's a sale on my merch store. 25% off in honor of our 250th anniversary. Just use code USA250. 25% off. Should I put the link? I should put it, right? Should give you a link. You don't have a link. How could it be your fault for not going there, right? The link's in the description, but I'll pin it. I'll pin it.
All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
A lot of the
Roof
the
was
candy
that bullet
stands.
found on?
I believe it was found on the computer science building on the roof.
A lot of the candy stands, in case you missed yesterday, making big stink about this bullet that was found on a roof of a different building. Which yesterday, another cop, I think it was Dave Hall, basically said that that was from it was never fired, that bullet, and it was a round that came from a cop who had cycled his gun, and lost the bullet.
On the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the Losi building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile and as a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up and fired. It still had the bullet projectile in the end and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. Are you've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but
ultimately a buccal swab was obtained from Mr. Twiggs?
yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs.
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Can we get those recordings now?
Mr. Twiggs' interview on April 20th, 2026.
Silent?
Well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the
It's not use of immunity, it's use immunity. Let's hear his definition before I tell you how good or bad it is.
individual during the limited time of their statement. They're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
That's the most limited type of immunity they can give him. That's the most limited type. As opposed to general immunity.
What offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview.
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time
Let's
to
fight it out.
address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first. And if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proper. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript.
So we gave them a copy of this recording of the Twiggs interview all the way back April 26th. They show up here in July and basically say, hey, we want to give you some redactions that we think is fair. So she's like, hey, you can't show up now.
Script of this recorded interview, how the state intended to present it, and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not.
And by procedurally, they mean as opposed to substantively, meaning you might be right in theory. Whether you're right doesn't matter because you didn't follow proper procedure in order to get the relief you're seeking that we should get redactions in this recording.
Not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds
You're
the
smart
proper
enough
scope.
to see
As
through
Mr.
the stuff
McBride
you're not
cited
supposed to
this morning,
consider.
several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is a quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy, asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper.
So just to summarize what she said has happened here. She said, we gave them the Lance Twiggs interview back April 26th. They show up here this week and they basically say, hey, there's all these different statements, a handful of different statements or more, I don't know, that are in there that are inadmissible for various reasons. And we don't want them there. So she's basically going to be arguing three things. One, procedurally, you're too late. Two, the suggestion that defense gave because of these statements was we want to redact the video or give him, instead of playing the video, just give a transcript and then take the transcript and presumably cross out the lines that they find to be offensive, to be a problem. And she's basically saying, under Utah case law, a judge in a preliminary hearing is not like a jury. He can see things that are inadmissible and understand intellectually to weed them out and disregard them if, in fact, they're inaccurate. They're inadmissible. She's probably going to argue about the admissibility of these various statements. But first, instead of going nitpicking statement by statement, this is admissible, this is admissible, she just wants to have a blanket idea of A, everything here should come in because they were too late, and B, whatever there's a problem with, you're a judge, you can see through that problem, and you can basically just pretend you never saw it and judge the case as to whether or not there's probable cause, irrespective if it flashes across your eyes.
If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
Because if we win...
So you're moving into Evidence State's Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge,
everyone
we
to see
believe, and I believe this has been discussed
Share with
before
us
on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right, and in regards to this exhibit, is in the, as State's Exhibit 16, is there any portion of that recorded statement that occurred before the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, so turning to the defense, Mr. Novak.
Thank you. Thank you, Ms. Hunt.
So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry, the court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 11:02 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning.
All of Monday, all of Tuesday.
In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made.
So what he's saying is it wasn't technically an exhibit. Yeah, but you knew that it was coming. You knew it was coming. You should have. You could have said something all the way back in April, May, June. You could have. You knew that they were going to be using this. He's like, well, it's been rejected. The court, it wasn't before the court until this week. So, come on.
This wouldn't be as much of a problem if Ms. Hunt had just said, to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 11:02. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 11:02 where Mr. McBride is basically...
Which, by the way, McBride is the lawyer who I was saying yesterday. Doesn't seem like a very good lawyer. He's the bald dude from the prosecution team, or balding. He's a younger dude. He does not seem very capable. So the problems that Novak is identifying, that it's basically McBride testifying and then Lance Twiggs saying yes, yes. So things like, did you, and then you sent this text message, didn't you? Yes. And this text message, instead of just having the guy testify himself, it's weaker lawyering. It's weaker lawyering.
Testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and group chat. I'm just going to distinguish between the two. And so this 11:02 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 11:02, those portions of the 11:02 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 11:02 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I'm not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So
You don't have a basis to raise
I'm
that
not trying
objection,
to
though.
create complications, and I'm definitely not.
You are
take
trying
the
to
state
create-
by surprise because I went to great lengths to provide the
totally
state with
is.
a transcript, with a proposed redacted transcript. And in fact, today we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it'll probably take a couple hours at the most. So maybe the
By the way, this guy he's a very good attorney. He is. He's advocating aggressively on behalf of his client. And I'm saying he's annoying and he talks slowly, but he's a highly competent attorney.
maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it until we're in the middle of the hearing.
Hey, CA
The
human.
litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed. That litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet.
No, you could have objected
In
a
hearing
long
in
time
which
ago,
the
though.
state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because because the exhibit contains significant content that is not admissible, even in a preliminary hearing.
So what he's saying is the reason I want to go to the procedural issue is because if we argue this based on merits, you're going to agree with us, the defense. So that's why she wants to short circuit and saying too late, too late, too late, too late. But the reality is substantively you would agree with us. So that's why she's trying to jump to that. It's a very effective way of trying to pretend that she's just ignore the procedural problems. Now, he gave some sort of basis to ignore the procedural issues, claiming that, well, it wasn't really proffered, but you knew it was coming. You knew it was coming. I mean, they tried bringing it forward, and they gave it 2 months ago. They tried bringing it forward earlier, so you knew it was coming. And hopefully the judge hits him on that.
So I'm going to stop now. But I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit, and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before I go to Ms. Hunt. So going to your first point in regards to this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine
Exactly what I
are
was
used by
saying.
Either
Good.
side on anticipated exhibits.
You should have
or
known this is
that may come
coming.
to court, and that allows pre-litigation. So
Yeah.
I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file.
Yeah, you decided to sit on this. You knew it was coming. Just because I'm not taking it in doesn't mean it's like, oh, I can't bring it up. You could have brought this up.
Regards to a motion in limine. But going to the
So you're trying to dismiss that there's a whole procedural issue. It's not your fault that it's so late because you're just coming forward as soon as the state is bringing it. You still could have brought this motion a long time ago. He's basically saying that's a crap argument. That's a garbage argument. That's what the judge just said just now.
I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that, but I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah,
best evidence?
Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I just
fine.
want to categorize it and put it in a box.
Is that a
So
best
what is the
evidence objection?
What objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here,
Sure.
because there are two exhibits that I'm very confident are coming. There are portions which are not relevant.
Thank you so much. You're awesome.
There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast.
The best evidence rule is that whenever there's two different forms of evidence, the thing that's most original is what's supposed to be admitted to the court, not some duplicate copy, not someone talking about what if you have a chair and you have a picture of a chair, you bring the chair, right? If the chair is a key thing, if you can bring the chair, but if you cannot bring the chair because it's moored to the floor, so in that case, you need to bring a picture of the chair. And then the next best would be a photocopy of the picture of the chair. So it's like you don't bring in, the person who took a picture of the chair, and now you have a photocopy of that. So that's the next best. You wouldn't bring a photocopy of a picture rather than the picture itself. So in the rules of evidence, you're supposed to bring the best evidence. So he's saying the testimony from Lance Twiggs about what it says in a conversation, in a Twitch conversation, or whatever social media platform they were using, his testimony about it is not nearly as good as the testimony itself, as the Twitch conversation itself. So bring in the Twitch conversation. Don't have him agreeing that that's what it says in a conversation, which is technically an accurate thing.
So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Okay. Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits,
it is
I want to hear
ballsy.
about that before the hearing, we certainly would have done so. And I think that is probably,
It's like, I didn't
for
know.
counsel, a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins so that the court knows these exhibits, there are no disputes. These exhibits, there are disputes. These are the disputes. And we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party.
You
It's
do
not
what
my
you're
job
supposed to
say,
do.
well, here's what you
Yes.
should do. Here's what you shouldn't do.
Exactly.
I'm independent. I'm not team prosecution, team defense.
I'm not sitting here
And so
guiding you on how to
I will
handle
not
your
dictate
case.
how you run your case. Obviously, if it goes against certain rules, constitutional rights, statutes, case law, I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution.
I got
do
questions
not
about
want to get into the
McBride.
business of saying, here's what you should do. I
Novak is
hear what
good.
you're saying, but I want to be clear from this point
Hunt
on,
seems
in case there's
okay.
any ambiguity. The court does not need to go into the business of dictating what you feel is in the best interest of your client to the state, what is in the best interest of your client. I stay clear of that, but I appreciate the point.
I told
you,
you.
and I hope that clarifies any ambiguity. That
I told you, he was walking a fine line there. He's basically saying, you could have told us to do that. And the judge is like, it's not my job to run your defense for you. You figure out what you're supposed to do. You're a very experienced guy. You figure it out.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger
For
on
me,
it.
this is like the most fun part of litigation. I love this part. I love this stuff.
On anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement. And we could have a conversation later if the court wants to. It's up to the court about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
So
Right,
sit
thank you,
down.
Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point,
When you're a lawyer, you never want to rely on procedural because you know that you're putting the judge in position to basically say, I'm catching you on a ticky-tacky thing, right? Even though you're right, I'm catching you on a ticky-tacky thing. So you definitely want to throw the procedural out there because a lot of judges will be sticklers for procedure. But you also want to give them like meat to sink your teeth into. So she really needs to address the best evidence, the hearsay and relevance issues that he raised, even though she probably has them on the procedural. But no judges frequently are very uncomfortable because they're like, I'm wrong on the procedural and he really is right. Now I'm really effing up. So, and I can be lax on the procedural and agree with him. So that's why she really wants to give him something to sink his teeth into as to why the defense is wrong about those other substantive issues of hearsay, relevance, best evidence.
about this not being by surprise. Yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and to our best guess,
Figure
come up
out
with
why
what
they
the
had a
substantive
problem.
Objections may be.
And that's very half-assing. It's like this is what we prefer. We're not going to tell you why we're objecting to the statements we want to take out. We object to them. We're not going to tell you why. Hey, here, this is what we want you to do. That's not really a very good faith presentation. You could have said why it is that you thought that these issues, that there were issues with the statements that you needed carved out. That's a great point. There you go. It's bucking into the procedural, saying he really effed up here. He really effed up. And when he tried remedying it, then even when he remedied it, he half-assed it.
I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing. And then probably, I don't know, I'm assuming the media attorneys will want to weigh into that because I do want to quote specific sections to be able to advocate for my position, state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing. And
So give me the
hear
win on
from
procedural.
The media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
He's going to take a break and think about it.
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time, and they're not for the public subsequently. It is very standard that sidebar proceedings where
Yeah, I'm surprised they
information
don't
is
have
only
more
to be exchanged
sidebars.
between counsel for the parties and the court are conducted at sidebar.
He's right about that.
Witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open
Right,
hearing.
shut up
to
and sit down.
whisper,
We got it. You want side.
the public,
We
potential
understand.
witnesses,
We
jurors,
we
potential
understand what
jurors
you
don't
want
get
here.
to hear what the court decides needs to be addressed in a manner which protects the party's rights.
All right.
Your Honor, if I may, Michael Judd on behalf of the media.
Now, yesterday, the lawyer
request
came
to
up
close.
on behalf of the media, which is a fascinating thing. I brought this up yesterday. They had another attorney there who was great. He was the best attorney in the room. And he was basically explaining why it is that everything has to be open under Utah law. And very, very on point with his arguments. So I'm not familiar with this. I don't know who this kid is. We'll see. Maybe he's good. Hopefully.
A court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview, that it's at issue here, is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing. There may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video. The public hasn't seen this video. It seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision
Highly
will rest.
important.
That counsels in favor of access, in favor of publication,
Yep.
in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks.
Good. He's doing good.
Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is...
This is likely a significant factor in your decision to find for probable cause or not. So the public has a right to know why it is you found for probable cause. And especially in this particular case, where you have all these different competing voices about what's happening and did Tyler do it or not, so if you're ultimately going to come out one way or the other, this is going to be a key foundation for that. The public has a right to know what it looks like. Great job, kid.
that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure, or
terrible.
keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible, and if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. I think that important. We take that, we recognize that it's important, we take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire, we can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comments
Very good job.
by any of the parties? All right. Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument a sidebar because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
we would like to have a very brief closed hearing to lodge another objection about the publication of this, of any portion of this exhibit.
Why?
Well, of certain portions of this exhibit.
That,
beyond
you have to argue
Your
why.
Honor's eyes.
Why?
That's what I'm saying.
thank you.
The media just pointed
All
out
right.
that to
Right
get
now,
that,
what we're
you
going to go
need
ahead and
to
do,
argue.
and what I want to do is I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's
Novak
correct,
is
Your Honor.
fighting
And what I
so
would
hard
suggest-
because this must kill
Well,
his clients.
If this works for the court, is we will email to the court staff
He must think this
with
is very
something we've already
damning.
given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the
Wow.
proposed defense redactions, and Mr. Ellis.
They're on this
can
break
make
for a
sure that
long
your court
time.
Staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural
Procedural?
objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break and then we're going to come back on the record. But on the break, I'm trying to maximize the time. And that's why I'm asking, is there any objection to me reviewing
He ends up
what it sounds
maximizing
like
the time.
defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go
Okay,
and
fair enough.
maximizing the time because we also want to put up a monitor. So there's like 3 things we can accomplish in the space of 15
Fair enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer. Just I want to make sure everything is in place. Let's come back at 3 o'clock and we'll proceed from there. Court is in a brief recess.
Yeah, they don't come back at 3 o'clock because as I'm looking forward here, you can see here on my screen that little state of Utah judiciary seal is up here. I'm 38 minutes behind. Okay, so it just stays. This is now 20 minutes later. 30 minutes later. Nothing. It's still the same thing. Still the same thing. I gotta think there's arguments that are happening in his chambers right now. We got live. Yeah. So they took a break here for close to 40 minutes. A short 15-minute break. This seems like it's a really, really big deal here. You're talking about the testimony of Lance Twiggs. So just to answer your question here, amazing. Disgrace. Every break I get to tune in to hear the argument of objection. Has it actually been that, or am I just unlucky? Well, there was a little bit of an extended argument that was going on here. We got testimony that came from Brian Davis, where he was talking about basically how he's one of the case managers of the investigation here, and gave us his whole experience here, and talked about Tyler Robinson showing in. They gave us a short video clip with no audio of Tyler Robinson coming in to presenting himself. And yeah, it was and presenting himself to the police, courtesy of Mike Mitchell, who's a family friend who brought him in. No audio, but he was wearing the same clothing as the guy who was filmed in the garage walking with a limp. So it helped further identify that it's probably him, although he came in on September 12th. The shooting was September 10th, so he's wearing the same clothing for 2 days, which I guess if he just killed someone and he's on the run and trying to take care of things, that might not be shocking. He's wearing the same clothing for 2 days. But yeah, so now this whole argument here is that he talked about how they had interviews of Mike Mitchell, the guy who brought him in, and interviews of the boyfriend, Lance Twiggs. So they want to basically present these interviews. The states gave this interview. It's a video recording. It's a video interview with a whole bunch of cops and one of the attorneys who is now litigating the case on behalf of the prosecution. And yeah, they basically are saying that the attorney is the one talking the entire time. And it's pretty much his own. It's like he's basically narrating everything, and Lance Twiggs just saying yes, 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 and agreeing. So he's like, that's not even him really testifying, which it is him testifying, but it's a sign of weak lawyering, and which is not surprising because we saw this guy yesterday. He doesn't seem like a great lawyer. One of the lead counsel for the prosecution. I haven't been very impressed with him. But basically, so they gave this over to the defense on April 26th, April 28th, around there. They also tried giving it to the court for the court to take. The court said, we're not taking this right now. We're not taking your evidence from you. So they said, and now the attorney for who's been questioning Brian Davis is this Ms. Hunt. She basically was like, they showed up this week and they say, here's your redacted version of what we want you to do with that interview. Here's a redacted written version, not even a video. Here's such a transcript redacted that we think should be given to the court. And she's like, are you out of your freaking minds? You want to play the whole video? You're telling me no video and just pieces of it in a transcript? No, that's not, I'm not okay with that. And she said that procedurally they had to come forward earlier, to which Novak, who I said, he's a good attorney, Novak, the one who's standing up there, the guy with the big helmet sized dome. He's a pretty good attorney. He argues very effectively. And he basically was like, look, it wasn't evidence before the court. So how can we object to it? Which that was an empty BS argument. And I called it that, and the judge called it that. The judge said you could have brought a motion in limine and said, because you knew they were trying to bring it forward. Hell, they tried depositing with the court. Of course they're going to try bringing it. All of a sudden you pretend, oh, we didn't know. You showed up with this here in July. This week, you showed up on Monday. And then Ms. Hunt also pointed out that they didn't even tell us what they were objecting to. Like, why? Like, what was your objection? Is it hearsay? Is it relevance? Best evidence? Apparently it's all of them. This is improper testimony. So meanwhile, you've got these attorneys from the media who are coming in here, and their position is just making sure that this is actually playing live. Yeah, their position is you have to have everything discussed here in open court. That's the way things work here in Utah. So the public has a right to see when you're making these decisions here. They have a right to see what you're basing a decision on, what evidence is being presented to you. And if there's an argument about what should be kept out of the courts, out of the public's view, you need to have the argument about why it needs to be out of the public's view in front of the public. So this way, if the judge agrees with you, we can understand what it is that swayed him into agreeing that this that, there should be a sidebar argument. Anyway, so the judge now, from the position of the prosecution with respect to this seemingly pivotal testimony on recorded testimony, well, it's not really testimony, it's recorded interview by the state and by the prosecutor of Lance Twiggs, where he was given use immunity. Use immunity is a very limited type of immunity, basically saying that what you're saying now, we're not going to prosecute you for what comes out of your mouth right now. In theory, they can come after you later. They have other bases. So they're giving him use immunity and getting him to get up there and testify. So, or make statements that are likely against his interests, and they cannot use those statements for purposes of charging him with any crimes. That's what the use immunity affords him. So he basically was asked questions about conversations that they had on social media, I think on Twitch or some other, I'm not sure which social media thing they use, but one social media that had the group chats. And so Novak says that should be inadmissible in the best evidence rules. You should bring in the actual social media conversation, not him agreeing as to the words written in a social media conversation. That is a classic best evidence issue. And then he says it's also hearsay, which does seem kind of like hearsay, although hearsay seems to be a problem that the court doesn't really worry very much about at this preliminary hearing. They will worry about it at trial, but there are in this preliminary hearing, there's a lot more slack given to the prosecution to get evidence in that they will not get that slack when they get to trial. And I'm not saying that they need that slack. The reason the court gives that slack is because when they talk about something that's, reliable, that's got reliable hearsay, is what the term that the court has used. They're basically saying, look, there are exceptions to hearsay, and there's reasons for us to believe the credibility of this hearsay. And if we made you go through all the hoops and the monkey bars in order to get foundation as to why this should be admissible, you'd probably be able to do it. But we're not going to make you go through that. Instead, we're going to forego all that and just say, for now, purposes of determining whether or not there's probable cause, we're just going to take it as a given that this is ultimately going to be deemed, you'll find a permitted way under rules of evidence to get this in a trial or something similar. So, or maybe you'll find other ways to get that nugget of information before the jury at trial. But we'll just have reasons to believe its credibility here and now. Even if you can't get the particular statement, you'll find some other basis to get this in and use it to substantiate your probable cause for purposes of obtaining that outcome from this proceeding. So this is so Hunt, on behalf of the state, her position is, hey, first we got the procedural issue. They had to bring this to us a long time ago. You can't just show up here on the eve of preliminary hearing and say, here's our redactions, and not even tell you why we're giving you redactions, and then just expect that the court's going to go along with it. That's ridiculous. You should have come to us with this a long time ago. You should have moved to the court and said to the court, hey, they're gonna want to bring this in. They've said they want to bring this in. Here are all the reasons and all the problems with it and all the things that need to be carved out of it. They could have done that a long time ago. And when Novak said, well, the judge never told us that's what he wanted us to do, he's like, I'm not your freaking daddy to govern you and dictate to you how you run your defense. Come on, you're seasoned. You're a pro. You've been doing this forever. You're pro ac vici. You came in here from some other jurisdiction. You should know what the hell you're doing here. You do. I know you got tons of experience. Don't pretend to me that I'm supposed to tell you to bring motions to preclude statements that are in some interview that you need me to tell you, oh, you should probably bring a motion on that before you actually walk into court on the day of a hearing when you had it for months and months. So, yeah, I think he's handling it well. And the unusual wrinkle here is that we get a counsel for the media getting up there and presenting all these different arguments, which I love that. And so far, counsel for the media, both yesterday and today, seemed very solid, very strong. basically saying, look, you have to give us access. And if you don't want to give us access, you've got to have a whole argument as to why we can't get access. And we get to hear the arguments about why we shouldn't have access. So we see whether the judge is leaning too hard the wrong way. And if there's ever been a case where the public really needs access, it's here, because there's so many questions as to the legitimacy of this entire thing. So many cynics out there, conspiracy theorists, Candestans, and all these other crazy people who are basically trying to come up with any possible basis to try and say that obviously Tyler Robinson is the only person on earth who didn't kill him. So I think that when you're trying to move forward probable cause, I think that we need to have access. So there have been a lot of arguments, but there's been some testimony also. That's the long and short of it. Amazing Disgrace. You're very welcome. I didn't even realize it was ad-free. What the hell am I doing going ad-free? Why am I ad-free? That's crazy. That's crazy. Also, CA Human, thank you so much. This is very generous. Very generous. And it's pretty much, this is actually 2 cups of coffee here in New York. So it's crazy. It's really, really crazy. Whew. I don't know when they're coming back. They're supposed to be on 15 minutes. They're supposed to be back a half hour ago, because he basically said come back at 3 o'clock. And in Utah now it's 3:30. So we don't know what happened to them. We don't know where they went. All this does is makes me really happy that I started 45 minutes late. Like, really happy that I started 45 minutes late. It was Discord. It wasn't Twitch. It was Discord. I think that was right. This could be the case. It really could be. But this is... And here's the thing. We don't know if they're going to come back in 30 seconds or in an hour. We don't know how. We have literally no idea. I assume they're going to come back within the next hour and a half before like 5 o'clock today. But they could be having a whole war there. In which case, you know, the media, counsel for the media would be really mad about the fact that they're not having that argument in front of us. I keep citing that Archuleta case. And it was interesting because he keeps saying that, you know, basically Archuleta lets you do whatever you want and disregard the media. And this is the first time we heard that. I'm curious about the Archuleta case. Let me see if we can find out more about what that says with respect to his right to keep things hidden from us. Let me grok me some information about that. Learn a little bit more about Utah rules of criminal procedure. Grok, in the Tyler Robinson preliminary hearing, the defense counsel keeps invoking the Archuleta case as far as justifying bases to keep things hidden from the public. Can you give me a little bit of background about that Archuleta case? And a citation.
It's a 1993 Utah Supreme Court case, State v. Archuleta. 2 guys were charged with a brutal torture murder, and the defense pushed hard to close the preliminary hearing and seal a bunch of the records and evidence. They were worried the gruesome details would poison the jury pool and violate their fair trial rights. The media fought it, saying the public has a First Amendment right to see this stuff. The court said, yeah, there's a presumptive right to access documents filed with the preliminary hearing, but it can be overcome if releasing inflammatory or inadmissible info creates a serious risk to a fair trial. They ended up keeping most of the pretrial docs and physical exhibits sealed, even though they unsealed the transcript. Defense lawyers love citing it because it gives judges a roadmap for when they can keep sensitive stuff hidden from the public and the press.
Can you give me a link to the case?
Sure, the full opinion's right here on Justia, law.justia.com. It's the 1993 Utah Supreme Court decision, 857 P2D 234. You can read the whole thing there.
So I want you to rest assured, I have the volume on here. We are live, waiting for the court to come back. So we're not missing anything, but we are going to inform ourselves about State versus Archuleta, which is what the defense counsel keeps invoking whenever he's trying to keep things out of our view. So it's not that long a case. Hopefully we run out of time in the middle. All right, defense Archuleta Wood arrested and charged with torture slaying of Gordon Ray Church. Homicide was committed in a particularly depraved manner consisting of physical torture, anal object rape, and massive bodily injury to the victim prior to death. Because of its sensational circumstances, the prosecution sought and obtained an order sealing the court files of the committing magistrate to protect the integrity of the ongoing investigation. Just before the preliminary hearing, Archuleta moved to close the hearing to the public to protect his and Wood's rights to a fair trial and to an impartial jury, because he figured they're going to come forward here and try and basically butcher us for this depraved murder. Because when you have something so depraved, very often you have the public wants blood and they don't care whose it is. The press sought intervention for the purpose of removing the seal of the record. Magistrate permitted intervention but declined to remove the seal on the court's files. The magistrate concluded that the preliminary hearing would be pervaded by prejudicial testimony and sensitive inflammatory evidence, including evidence possibly inadmissible at trial. To protect the defendant's right to a fair trial, he ordered the preliminary hearing closed to the public and the record of the hearing sealed. After the preliminary hearing, which both defendants were bound over for the 4th District Courts, the press continued its efforts to access the pretrial documents and the preliminary hearing transcript. Judges Bailiff and Park, sitting jointly, conducted several hearings on the matter, trying to decide what should they release to the public. At the second hearing, beginning on September 7, 1989, the court heard testimony from several witnesses and received evidence concerning jury studies, print and electronic publication of the case, and reports reflecting the experience of the 4th District in seating an unbiased jury in a similarly sensitive case. Prosecution also presented evidence related to its ongoing murder investigation, which it claimed would be... What?
Court is back in session.
No, let's go. Let's go.
In the presence of counsel and all parties, I appreciate your patience. Sometimes it takes time to save time, and so that was the intent of this court in addressing what is before this court as it relates to State's Exhibit 16. Counsel, this time I've taken time to look at the video anew, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing all parts of it in great detail.
And
all right, I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees it is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16.
So what he's saying is that the reason for the hearsay was to give Twiggs context not to assert the truth of the matter of anything that was asserted in the statement. So it's not for us to believe that, let's say, there was a conversation. It's to give him context as to when things happened or stuff of that nature that McBride said. So that's not an actual hearsay problem, he's saying.
And
But you framed it
I
funny.
agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to like scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout.
So he's basically saying, I'm not going to worry
this
about relevance
hearing.
issues.
And after this hearing, my intent is to review everything again. To be thorough. This is not a case where I'm going to be shooting from the hip and making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit 16 may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. And therefore, as it relates to relevance, that ruling is reserved.
In other
Now,
words,
turning to the other objection, which is rule.
in other words, maybe some of the stuff which seems irrelevant, based on evidence that will come out later, it'll become relevance become clearer. So I'm holding off on that for now.
403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255 until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one
at least we're getting that.
portion. And when I say audio, I mean audio and video. So both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today,
give us the audio. Go.
Up until
from
the beginning. Until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Ronald, would you state those times again that you are ordering not to be published? I've got 32:55 to 35:48.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and State's Exhibit 16.
And that's from 32:55 to 35:48.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Yes, Your Honor.
Of course.
And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because I
Sure.
do think a closed hearing is appropriate. Setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay, Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay, I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule.
Okay, so what's your point?
But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the due process clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to, which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology, but I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights right here and now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it, because the court's decision to allow this video to be televised and the other two exhibits to be
It's trying to scare the judge.
shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
So, and I appreciate that clarity, and perhaps, and again, if you
He's
want to
threatening the
make
judge.
and we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it? In
It is not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important. And I recognize that you're advocating for your client. And so I want to give it its due time. The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported in part the charges that the state has filed. We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a motion, but Mr. Novak, I'm not sure if that's ringing any bells.
I'm aware of the issue that the court
That guy with the glasses is
commenting on. I think the
McBride.
state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that, certainly not the court. And I'm confident that the state's counsel would never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party. We have not filed anything in this case that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into evidence, and the court knows what this note is because the court's now watched the video. That's another piece of the same.
The note is, I'm sorry, I had to do it. I had no choice.
This is all simplified.
We've all
by
seen
the
the
court
note.
being extra cautious about
We've
Mr.
all seen it
Robinson's
already.
constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right. I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this. And I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything audio and visually displayed, but the state's position is we just want the audio played.
Right, but what's it? So I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
So help me understand what's the difference if the audio's played or the video's played on what the court is identifying is what. Well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. And I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twiggs' video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within state's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then in the future move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with the audio. But hearing the tone, the context, all of that, that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
Oh gosh, we know
a
what
long time ago that when that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now, I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
Okay, we got it. You're very clever. Yeah.
Citation to state standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me at least 3 times about what we think the court should do here. It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right. Thank you. I appreciate both parties advocating and arguing. It's helpful for the court.
Well, make a decision, Judge. That's why you get paid the big bucks. Make a decision.
All right. So in taking into consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8, and sorry, I'm just trying to. Sorry, starting on page 7, right after 8, is that at 8?
He's trying to figure out which part of the admissions. The confessions.
Well, let's start. Starting on page 6. Now,
5. Let's go back to 4. Starting on page 2.
Starting on page 6, after 6 minutes and 56 seconds. going to 20 minutes and 27 seconds for reasons such as 403, under Rule 403.
14.
And again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State
We're not
Exhibit
gonna hear it.
16. But the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish
It seems you're cutting
the
out
court's duty as a
half of it.
magistrate under the probable cause determination.
You're cutting out half of it. What the hell?
All
is
right,
Can you state those times again, Your Honor?
6:56 until right, the line before 2027.
Oh my God. It's 13 and a half minutes.
Or 2027, just so until 2027.
It's
That-
cut- it's ridiculous.
And then and then what the court indicated previously
Although, to be fair,
from,
I far prefer him being cautious and convicting this asshole
3255,
than him being reckless and
Until-
opening up a procedural basis for him to walk.
3548.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 3255 to 3548 and 656 to 2027, those are just not being published, but they have been admitted for Your Honor's consideration.
Right, so kind of going through my three-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and and captured by the video is the differentiation. So what's being redacted, for the lack of a better word,
I think Twiggs was in
or
on it.
cut out, is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own
We
determinations.
got it, Judge. You're just not letting us hear it. You're considering everything. You're not letting us hear it.
Everything that Mr. Novak noted, I'm taking that in consideration and making those determinations, which the court will do again.
He's very afraid of having an appellate court coming back and saying, you dropped the ball here and you screwed up in allowing that confession to be aired. He's terrified of that. So that's why he's saying it's all admitted. I'll consider all of it, but the public's only going to get to hear selected portions of this thing that I'm considering.
Because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where,
And that's true. We will see that trial.
as it relates to publication.
Yes, thank you.
All right, to the media.
This is whack, Judge.
Thank you, Your Honor. I know how much time the court's already dedicated to considering this, and I appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper
This
means
is the decision
and will
he's
promote
referencing.
conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that.
This is what he just referenced, this part right here.
But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there. Something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case.
We already have it.
Thank you. And all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand.
There's a cousin of mine.
Defense and the judge, you're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to.
She wants
That's
the
it,
world to
Your
see
Honor.
how guilty Tyler Robinson
To
is.
not be transparent here, to not be open, to not let the world see what happened will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue
This
my
isn't
final
weighty
ruling
enough.
to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and that your mic's muted.
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions being put out to the public. Could you cite two Estes that supports?
The portion that the court is looking at is exactly what I would read to the court. It says, we constructed a rule. Now, I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions.
Mm-hmm.
But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial vis-a-vis that earlier televised analysis. So yes, we could go down what lawyers like to do. We could go down the rabbit hole of what were all the different opinions in Rideau and why is Estes citing to a dissenting justice. But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg.
Settled court.
And then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So taking into consideration all the factors, the previous edits, starting at I believe I said starting at 6 minutes and 56 seconds, going to $20 and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 3255.
This is a bit of a different thing.
Until 3548. Does that comport with what I previously said?
Yes.
All right. And then from 3548 to the remainder 37, can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes, under my analysis, under 403, going to the last part, needlessly presenting cumulative evidence, and based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act, but I'm trying to act in the interest of justice in making this balancing act, and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
We're going to have just a moment.
Of course.
So tomorrow morning, we're going to open by hearing this redacted audio from Lance Twiggs being interviewed. And I'll tell you, this is
and I know the state's engaged, but if someone could send a copy of
he's
that
being ridiculously
to the
cautious
court
here.
after it's been reviewed by counsel, so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well. Thank you.
Over there, they felt it was prejudicial. In Estes, they felt it's prejudicial, and Rudeau, it's really unfairly prejudicial for the world to see this guy confessing to a crime. That's very different from being unfairly prejudicial for someone to claim that he confessed to a crime. That's not nearly the same thing. What we're talking about is Lance Twiggs coming forward and saying, Tyler confessed to me that he killed Charlie Kirk. So that's something which is
Judge, it's the state's
not
position
nearly
that
as
we
prejudicial.
close for today. Come back once those edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No.
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis, as to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord and the note. All of that is part of the SD's issue. And I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand.
I'm going to review.
I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to
this guy here, by the way, is Brian McBride.
Statements that
this guy whose head I'm circling my arrow on is Brian McBride. He's a prosecutor.
So maybe that's something.
It was a different.
I'm going to be talking about Brian
addressing.
McBride when I'm explaining everything here.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
This
Right.
is Novak
Understood.
over here.
But if the court wants to
Lawyer
recess,
arguing
we
now.
have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion. And I want
because when you look at SDs,
full consideration.
Novak here is really
It's a
overstating what
suggestion. If you
SDs
can, I
seems
know
to
you're
say.
extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time, so that at 9 a.m., the court has already had an opportunity to understand what's coming. We're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank
No
you,
problem.
Mr. Novak. And if you would mind, obviously, sending a copy to the state as well.
Oh, of
so
course,
it's not
of course.
ex parte. All right.
So, is the court referring to a formal filing?
No, just if
A
you
bench
want
memo?
a bench memo, and that all sides can have take a look at, just to prepare, again, in light of efficiency and trying to maximize our time.
Get it to the
and
media
give
too. Let
as
them argue about it.
much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when
Get it to the media
it's a little
too.
difficult. So
Happy to do so.
if you'd like to,
Get it to the media.
I would entertain that. to
Media
the
lawyer.
state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right. All right. Is there anything else for this afternoon?
Not from the state.
All right. To defense.
No, thank you very much for your time, Your Honor.
All right. Court will be in recess until 9 o'clock tomorrow morning.
Okay, so I'm going to explain to you what went down over the last hour and a half or so. Okay. Let's just to give you a synopsis of everything that happened here. So, because it was a little complicated and it's important. Let's take down my banner here. I will remind you to please hit like and subscribe. That lawyer I was circling who was sitting down there is Brian McBride. There was an interview that Brian McBride did of Lance Twiggs, Tyler Robinson's boyfriend, together with the officer who was on the stand, which is Brian Davis. The two of them were there together, and another couple of officers as well. During which time, Brian McBride there, the lawyer, was asking a lot of questions of Lance Twiggs about what happened. It seems as if during the course of that, we don't know because we haven't seen it, but there was a video which seems like it's like 37 minutes or so based on what's implied of this recorded interview. The copy of the recorded interview was shared by the state with defense counsel on or about April 26th or 28th. I don't remember the exact date they said. They also tried giving it to the courts. The court said, we're not taking it at this time. We're not taking your evidence at this time. They wanted to have it there. I'm not sure for what reason, maybe it's part of a motion, but they wanted the state to basically take it. This is messing with color. So the court said, we're not taking that at this time. And that was pretty much the end of it. Now, when the state basically informed the other side during our preliminary hearing, we're going to be bringing this forward, and here's a list of all the evidence we're going to be bringing in here. This piece of evidence, this Exhibit 16, which is this recorded interview, is up there. It's things we're going to put up there when Agent Brian Davis takes the stand. On Monday this week, so what, you're talking about July 5th, nearly, 10 weeks later, the defense counsel comes to the state and says, hey, we don't like some of the statements in here. We don't think it's admissible. We don't think that that can become part of the case and needs to be redacted. So we don't want this thing redacted. We don't want all these statements in here. Included in there is confessions from or what we're expecting are going to be deemed confessions of statements that Twiggs will likely say that Tyler Robinson made to him about killing Charlie Kirk. Also, things about that came up during a Discord conversation, which the different parties were involved in, and statements of that effect. So what the defense came along and they said, here's a redacted, this is what you should be presenting. And carved out various sections of and it wasn't a video recording. They didn't dice that up. They basically made a transcript of the entire thing and said, here, all the stuff that we're highlighting, all that stuff is inadmissible, shouldn't be in there. So when counsel for the state got up there, Hunt, and she's like, they want us to use this redacted version. We want to have the full version. We recognize out of respect for the rights of the defense of the accused, we're willing to have it just be audio for the entire world, but we want the entire thing admitted, and that you should see the video, people in court should see the video, publishing to the world should just be audio, and the entire thing, no redactions. And we're also telling you that we have a problem with what the defense did, because defense got these papers from us. They knew about this evidence back on April 26th, and all the way back in April, and they show up here on Monday of a preliminary hearing, and they're coming in here and they're saying to us, hey, we don't want that whole thing there. Here, use this redacted printed paper edition instead of the full video edition. We don't think that's fair. We think that there's a procedural flaw with that claim because they had a duty to come forward to us earlier and tell us that they had a problem. So they don't just come to us with this. To which Novak, on behalf of the defense, came forward and he said, well, there was no evidence before the court. When they tried giving it to the court in April, the court said they're not taking it. And then as soon as they proffered it and they said they're bringing it here this week, we said, well, we have an objection to it. This was a bad faith argument being made by Novak, which the judge called him out on. He's like, just because it's not before me, you knew they were going to bring this here. You could have brought what's called a motion in limine, a motion related to an upcoming hearing, and saying, when we anticipate this is going to come up, here are our objections. And you could have done this back in May. You could have done this back in June. Another point that Hunt made on behalf of the state was, even when they gave us these papers, they didn't even tell us why they were carving stuff out. They didn't even tell us what their objections were. They were just like, well, we don't like these lines. They didn't tell us whether it was it was a problem of hearsay, of relevance, best evidence, which is another possible objection. They didn't tell us anything. They gave us nothing. We have no idea why the hell they did this. They just said, we don't like certain lines in here. So what are we supposed to do with that? That's not a good faith argument. And the judge seemed to take issue with it. And he said, well, what about, those are called, that's a procedural issue. You didn't follow proper procedure in objecting to this in a timely fashion. Maybe your objections are great. They're really phenomenal objections, and you're right that all these lines should be out. But since you came so late we're just going to ignore these objections because you suck. You should have done this earlier. And Novak for the defense is like, well, what were we supposed to do? And he's like, you could have brought a motion in limine. So Novak says to the judge, so if you're telling us that that's what you want me to do going forward is bring a motion in limine? And the judge quite properly said to him, I'm not your daddy. Didn't use those words. I'm not going to tell you how to run your case. You're a very, very experienced attorney. You're a very, very experienced litigator. We've seen a lot of experience on display here. You know what you're supposed to do. And I'm not going to dictate to you how you should handle your case. I'm not going to tell the defense the state how they should run their prosecution. You're all experienced attorneys. Which is basically saying, yes, of course. Of course you should. You know that because you're an experienced attorney. You should have known that. You're admitted pro hac vici. Admitted pro hac vici, in case you're unfamiliar with that term, means you're not licensed to practice in this state, but you're so highly regarded by the defense. They brought you over from another state and said, we want you in here because you're that experienced. You're that good. So if you're that experienced and that good, you should have known to bring a motion in limine to have these redactions issued there. Anyway, so then the judge said, let's talk about let's assume that there wasn't a problem with the timing. What are the overall issues that you have with some various statements in here? And they said, well, and then there was a whole argument. Do we discuss these redactions in front of the camera, in front of the court? Because one of the things that the Judge Graff is very concerned about is he seems to sincerely want to follow the law of keeping transparency. And under the law, there's supposed to be transparency. That we, the public, have a right to know what factors are being presented to Judge Graff when he decides whether to bind this over to bring it to a jury for a jury to basically hear his these charges and potentially convict him of murder, potentially sentence him to death. So, or to deny that and basically dismiss the case without letting it ever get to a jury. So we, the public, have a right to see that. That's what this whole objective of this preliminary hearing is. He's very mindful of that, so much so that he even allows attorneys for the media to come up and present their basis for arguing. And one of the things that they've been arguing about, because the defense wants the public to see nothing, and they keep saying the more the public sees, the more damning it is to our client that they're going to basically decide he's guilty before he even gets to the actual trial. And all the jurors who are going to come in here, they're all going to come in here saying we're here to hang Tyler Robinson because they're all going to have heard just how all this terrible evidence without really hearing it in proper context and form. And he's not going to have a fair jury trial. So, he's trying to keep everything possible from the public, the defense counsel Novak, and the judge seems very mindful, and the media, they want everything for the public. That's the attorney for the media. And then you also have the attorney for Charlie Kirk's family, for Erica Kirk, which basically is like, hey, we want everything public also because we're really sick of the fact that the entire world thinks this isn't the guy. So we want everyone to be able to see that it really was Tyler Robinson who killed him. And not having this lingering. Now, I should point out to you that since this came up from my audience, this is very important, that whatever is kept from us today likely will not be kept from us at trial. The whole objective and the basis for the defense to basically say the public can't see that, public can't see it, is because he's worried about poisoning a prospective juror. Some person from Utah who doesn't realize today that 6 months from now, 9 months from now, he's going to be sitting on a jury. She's going to be sitting on a jury, is going to be hearing the news, seeing clips on Facebook, on X, on whatever social, on YouTube, which are basically displaying damning evidence against Tyler Robinson, and it's going to poison their minds against Tyler Robinson, and then they're going to end up being selected to sit on the jury, and they're going to come in there with a poisoned attitude before the defense even has a chance to begin their case. So, but once we actually get to the trial, now there's no reason for everything not to be presented to the public. So all these arguments about keeping these things from us evaporate once you have a jury that's already selected. So we should look forward to the fact that whatever is redacted from us today, one day, and whenever we get to a trial, assuming it's bound over means that the judge finds there's probable cause, which I'll tell you right now, everyone thinks it's going to be bound over. There's no one who thinks for a second this is not going to be bound over. Even the defense knows that. The defense's main goal here is they want to try and convince the judge that I'm going to give it over to a jury, but I'm going to take capital punishment off the table. That would be a massive win for the defense if they can get that. They have no expectation whatsoever that they're going to keep this from going to a jury. But still, so they basically are going through this process, trying to get capital punishment off the table, and also trying to keep a potential juror from seeing anything come out of this and being poisoned and deciding that they hate Tyler Robinson before they even come in to the jury trial. And no one today knows who those, even the jurors themselves, no one knows that they're when they're going to be selected for a jury. So now you have this critical piece of evidence, this Exhibit 16, this interview of Lance Twiggs, boyfriend Tyler Robinson, the person he confessed to, love of his life, furry in flagrante delicto, besties, roommates, who there seems to be some evidence presented so far, likely had a far greater role in this whole thing than the public has been led to believe, if only because of the fact that his DNA is at the crime scene too. Now, maybe it's because, Tyler used a towel that he was used there, whatever, but anyway, when he did that interview, he had a use immunity. He was granted use immunity, which means his statements cannot be used against him. Now, they might find other evidence to come after him, but those statements themselves cannot be used against Lance Twiggs to convict him for being complicit in this crime. Now, what are these statements and what are those objections? And the judge spent 45 minutes going through the objections, the statements, and looking through this transcript that the defense counsel said, we're putting in a highlight all the statements that we think should not be admissible. And when they put this out there, they basically said, okay, here are some of the objections. Some of it they're saying is hearsay, meaning statements made by a third party that Lance Twiggs is talking about, that's hearsay. Statements made by Tyler Robinson would not be hearsay because that's admissions, but statements that are made by a third party would be potentially hearsay. You also have best evidence. The rule of best evidence is that, and this applies in every court in American jurisprudence, that you're supposed to present the best evidence available. Original source material is and you're not supposed to be giving duplicates if and when there's original source material. So if you have a conversation on Discord, and there's screenshots of a conversation on Discord, on Discord, and now you have somebody saying, what does this statement on Discord say? And he says, does this statement on Discord say, you're so cool, I wish I was you? Yeah. And then the next guy says this on Discord. Instead of having someone say what it says on Discord, best evidence is just introduce the Discord chat. The juror, the trier of fact, in this case would be the judge of the trier of fact, that you can just decide, he can see for himself what it says there. You don't use second best evidence or secondary evidence. That's a best evidence objection. So he's saying you have this interview here where Brian McBride, this attorney who has frankly struggled a little bit, in my opinion, when he's been handling this case so far, when he's been interviewing, when he's been on conducting direct examinations. I've not been impressed with Brian McBride, who I think might even be lead counsel for the state of Utah on this thing, which is frightening. But that he's the one who conducted the interview, and during the course, the way he did the questions is he goes, it basically, according to Novak, we haven't seen it yet, but Novak implies that Brian McBride basically would be like, talk, and then you did this, and then you did this, and then he said this, and then you did this. Is that right? Yes. And then you said this, and then you said this. Is that correct? Yes. So instead of Lance Twigg basically telling the story, it's Brian McBride telling the story, and Lance Twigg saying, yes, yes, yes. And then you did this and you went here, and then he called you and he told you that, and he told you that he was at UVU. Yes. And then you saw him here. Yes. That's the healthier way to conduct an interview, is to say, and then where did you go? And then basically let Lance himself tell the story, not you feed him words for him to say yes to. So he's saying basically it's improper questioning by Brian McBride. It's basically Brian McBride testifying and then, Twiggs nodding along, yes. He also says there's best evidence issues. He says there's hearsay issues. He says there's relevance. There are some of the statements that are in there are relevance problems. And he says other stuff is prejudicial and he also said there's potential privacy issues. So he has all these different issues that he brought up. Now, what happened? So the judge basically went through all these different things and started making different findings. When he came out, he goes, okay, with respect to your different issues, here's my finding, boom, 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 on each of these. Some of them he says, I'm overruling you on the hearsay thing, on the hearsay, and he gave his basis for overruling him on the hearsay. And then he brought up the relevance, and he said, look, to the extent that anything is irrelevant, because this is not in front of a jury, relevance is more a problem when you have a jury that's sitting there. But I'm sitting here as a judge trying to determine facts. I can weed out the stuff that's irrelevant. A juror might get all confused by things that are relevant. But under the law, we recognize that a judge is more equipped to weed out things that are irrelevant. So I'm not going to really worry so much about it. I'm overruling you on those issues. But some of the stuff he did seem to have concerns about, as far as being prejudicial. So he said, and he also had concerns, and one of the things that Novak succeeded in scaring him about was that he said that Novak got up there and he said, we anticipate that when we get to trial down the road, one day they're going to be, assuming this gets bound over and that there is a jury trial, they're going to present this interview again. And they're going to present this to the jury. And then they're going to get for closing arguments. And you're going to say, you heard Lance Twiggs say blah, 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 blah. And that was a confession. That was a confession from Tyler Robinson. He confessed to this crime. And he said, since the state is going to claim this is confession, there are special rules under the Supreme Court as to how we deal with confessions. And one of them is that under the case of Texas versus Estes, the Supreme Court said that you cannot, at a preliminary hearing, air a confession because it's so highly prejudicial to a defendant to have his confession televised to the world. Because how the hell is he ever going to get a fair trial? The entire world sees him saying, I slaughtered that man, I cut off his wrists, and then I hanged him from the rafters. You see this whole confession from him. You think anyone's going to be able to see that at a preliminary hearing and be called as a juror and actually be impartial? We can't. The Supreme Court says you cannot televise this. So even if you're going to have something open to the public, those cannot possibly be shared with the public because it's impossible to get a fair trial. You're stripping him of his due process rights, of his rights to a fair trial. So the Supreme Court, so he said, since the state is later going to call this a confession, some of the stuff that comes up in this interview with Lance Twiggs, under the case of Texas versus Estes, and which relied on an earlier case called Rideau, that under those two cases, you cannot publish this, and I don't care if it's an audio or video, you can't let the world see this at all because you're stripping my client of his right to a fair trial because the Supreme Court says that is necessarily something that will deprive him of being able to have a fair jury. So he says that's something that you must take, you must remove. You cannot let the public hear that. Now, the judge had already carved out 3 minutes of this 37 minutes, judging from like 32 minutes and 46 seconds until 35 minutes and 51 seconds, basically 3 minutes near the end of it. But he said, no. There's other stuff that comes up earlier, which is under the Supreme Court decision, according to defense counsel Novak, that the Supreme Court mandates that you have to carve that out, that the public cannot hear that. And the judge over here seems to really care about presenting to the public, but he also seems very afraid of basically screwing up and potentially, harming his right to a fair trial and being humiliated. That if this kid ends up walking, Tyler Robinson walks because he ends up screwing up here in how he presides over this. This is something that will dog him for the rest of his life. So he's going to err. He's going to err on the side of ensuring that he's not possibly found to have violated his right to a fair trial in a way that cannot be remedied. So he's going to err very cautiously on that. Now, personally, given the very limited look, which I basically had like 2.5 minutes to pull up that case that I brought on screen here of Texas versus Estes. And if you look at that case, to me, it seems as if I actually have it over here. This is Estes versus Texas. And I can bring it up for you here, where basically what the court says is, in Rudeau versus Louisiana, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without showing a prejudice or demonstration of the nexus between the televised confession and the trial. Here, although there was nothing so dramatic as home-viewed confession, there had been a bombardment of the community with the sights and sounds of a 2-day hearing during which the original jury panel, the petitioner, the lawyers, and the judge were highly publicized. The petitioner was subjected to characterization and minute electronic scrutiny to such an extent that at one point the photographers were found attempting to picture the page of the paper from which he was reading while sitting at the counsel table. So there was a whole so they basically are referencing that in Rudeau we made this rule saying that you cannot, that it's considered, it's prejudicial, it's inherently prejudicial to put on television, to televise a confession. So now if you actually look at this case of Rudeau versus Louisiana, and you click on this link over here to pull that up, I don't want to do that. If you click on it, it's not even so clear the Supreme Court is accurately reflecting its own position. That's 729. It's not even so clear. It says, second, I agree fully with the court when it's the private process law when he is tried in an environment so permeated with hostility that judicial proceedings can be but a hollow formality. This is not, I mean, I don't know how they get to, Estes takes a little bit of a leap from what Rudeau seems to say. But here's the thing. What makes it so prejudicial, you would think, is if the whole world sees the guy saying, I did it, I butchered that guy. That's very prejudicial. But if the whole world sees this guy say, he admitted to me that he did it, that's not the same thing at all. That's not nearly as prejudicial, because everyone will be like, well, that's what Twiggs is saying, but who knows telling the truth? That's not nearly as prejudicial. So Novak, it's in his interest to basically frame this as if it's a confession. It's not a confession. It's an admission by Twiggs that Robinson confessed. That's very different from actually hearing Robinson confess. So I think that the judge is showing an abundance of caution that which is likely not necessary. But so far, he basically came back and he said, all right, let's carve that out. I want to hear more briefing on this. I don't really know enough about Estes versus Texas. So I want you to come back to me tomorrow, Novak, with the law on this. But let's prepare. Well, the part you would need to carve out is from 6 minutes in until 20 minutes in, and then from 32 minutes in to 35 minutes in. When all of a sudden now, what are we left with? We're left with the first 6 minutes and then 10 minutes afterwards. So it's 37-minute video where we're going to end up getting 16 minutes of, more than half of it being carved out now, apparently, or roughly half, which that sucks, and that's what we're supposed to open with tomorrow. So this was an important thing because it seems as if this piece of evidence is potentially very, very damaging. The other thing I should share with you is that the judge says that he is going to admit all of it and consider all of it and even the most damning parts when he's deciding whether to bind it over, which means that if there is confession, if there is a confession in there or something similar to that, in that case, we can, he's not going to eliminate that. He personally is going to consider it and use that as a basis and potentially to bind him over for a jury trial and say that he's got to go to trial. But the limitation is that we, the public today, don't get to see it now. And we spend until this actually comes out at a trial 6 months from now, 9 months from now, a year from now, whenever the hell this trial happens. At that point, we'll be able to see, one would expect we should be able to see the entire Lance Twiggs statement and potentially see Lance Twiggs on the stand himself. Likely, you would think. So that's where we're at today. That's what we had today. Tomorrow, we'll hear more arguments on this, probably at the start, and then we should be seeing a video. And I expect to be streaming this tomorrow morning. I hope you're going to join me at that time. Make sure you hit like and subscribe and drop a comment. I hope I made this crystal clear for all of you. And yeah, that's what I got for you. Did I miss anything? Oh, I did. I missed here. And Rosemary Taylor says, "Is your trial coverage is anything close to your preliminary hearing coverage? We will be glued to good logic." Well, thank you. That's very, very kind of you. I appreciate that. When I cover this stuff, I do it pretty much like what I'm handling here. I like letting them speak. I'll throw in a little comment here and there. I never want to overtalk the testimony unless it's really stupid and boring and something that no one could possibly be enraptured by. And I want to make sure, and I try to like zone in on the parts that I think to myself, if I wasn't a lawyer, I wouldn't really know what the hell's happening here. And to me, one of the most fascinating parts is when you see these legal arguments, because this is you really get a flavor. This is trial right here. This is what it is. The legal arguments, the mistakes, the strategies, and identifying which lawyers are making good arguments. Like with Novak, I can tell you he's boring, but he makes solid arguments. He makes arguments, and you can sort of see the wheels spinning in the judge's brain, and you understand. If you just put yourself in his shoes, how would I feel if I was there? You can understand him being afraid of screwing this case up and harming Robinson's rights and going down in notoriety as the guy who let Robinson walk because he effed this case up. That's a terrifying feeling. So you're always going to err on this side, making sure I'm not stepping on this kid's rights. Otherwise, I can be my entire career. Goes up in flames. So I think that he's probably going to keep those redactions because out of abundance of caution. Although I don't think under the law he really does have to keep those redactions. I don't know about those 3 minutes and 32 to 35 minutes, but I do think all the stuff that he was originally going to allow in, all the stuff that Novak was claiming that the state's going to call that a confession. I don't think any of that is from the limited review. All I see, Estes v. Texas is what I just showed you now. I only heard of this case because they brought it up. So, but based on what they're describing here, it seems it's not really such a firm holding, and that it's not really on such firm grounds, because it sounds as if Estes v. Texas is sort of twisting into what Rideau versus Louisiana, the Supreme Court said Rideau versus Louisiana 2 years earlier, and now he's stretching it even further than what it says in Estes v. Texas, because Estes v. Texas is talking about the defendant himself confessing. That's very different from an interview of somebody saying he confessed to me, which is not nearly as prejudicial. If I come to you and I say to you, Tyler Robinson confessed to me, you think that's nearly as prejudicial? Just think this through for a second, right? Let's say let's say I knew Tyler Robinson, okay? Let's say I actually knew Tyler Robinson. Obviously I don't. But let's say I really knew him. Let's say I had been friends with him. I said, you know what? Tyler called me up and he confessed to me. Is that really the same level of prejudice as you see a video, and that video clip of me goes around the world? Everyone sees me say, Tyler Robinson told me he killed Charlie Kirk, right? Everyone sees that. Do you think that's nearly as prejudicial as actually seeing a video clip of Tyler Robinson saying, so that's when I pulled out my gun and I shot Charlie Kirk? That's not even the same ballpark. Those are not nearly the same things. But Novak, on behalf of the defense, because he's a good lawyer, that's what a good lawyer does. You try and basically take what's there and build it into a cake and make your argument here. And he's sort of hoping that the judge is afraid of screwing up, and that the judge will be like, let me be careful here, and not risk violating, stepping on what the Supreme Court said. But Judge Graff, to his credit, seems to be a little concerned of that. That's why he's like, I want more briefing on this. Give me your perspective on this. We would anticipate that the state would do some briefing and say, no, here's why it should be public. And not just the state, but then the media, because the media's attorneys have been very solid, very solid. I've been very impressed with the media's attorneys. Like very quick, pointed arguments and not backing down that everything needs to be public. And if you want to get something in private, have a sidebar conversation that we don't get to hear, you need to argue why you're entitled to that, why you're entitled to keep that, why it's necessary and essential, and have that as limited as possible. Because we were right here to see everything. Great job. And I see that you sent me that twice, Rosemary. So thank you very much. I'm going to give you the horn for that, Rosemary. Sorry, God bless you. All right. I'm going to land my plane here. God willing, I will be streaming tonight around 10:30. My regular nightly show. I plan on having Cynic joining me. And I will see you all then. Plus, tomorrow morning, 11. Sometimes I prefer to start like a little late just because there's so much wasted time. And that way I can sort of push it all in together and not have the wasted time. And we all get through it faster, get the same information. We're just watching it 15 minutes, 15 minutes later. So I like watching it starting a little late. So that's going to be probably I'll start like 11:30 tomorrow. Anyway, so I hope you catch me tonight. If not tonight, tomorrow. Follow me at goodlogic.locals.com so you get notifications of when and where I am. Make sure you hit like and subscribe, all that other good stuff. You can check out my merch store. It's pinned in the comments. It's in the thing. I have a special discount this week, 25% off if you use USA 250. And yeah, I'll see you all later. Until next time, Godspeed.